we're good to go. Good afternoon, everyone. Thank you for attending and welcome to our webinar, Using Digital Forensics to Win Litigation Cases. I'm your moderator. I'm Judy Miller. I'm the Managing Director here at ERM Protect Cybersecurity Solutions, located in Coral Gables, Florida. As billed, today's webinar will discuss how to use digital forensics evidence in court. The session will last about 60 minutes with time at the end to answer your questions. So please put your questions in the chat and I'll be sure that the speakers get to those at the end. Next slide. We've broken the webinar up into 3 logical sessions of about 15 minutes each. The first part of the presentation will explain what constitutes digital evidence, where it can be found, and common challenges you might encounter in these types of cases. Our speakers for that section will be Esteban Foro. He is a cybersecurity director here at ERM Protect, and Chris Sanchez, who is a cybersecurity manager here. Esteban leads the company's digital forensics, security, and data compliance practices. He has more than 25 years of experience handling data breaches and producing digital evidence for litigation. Esteban has a master's degree in information security and 11 certifications related to cybersecurity. He will be joined by Chris. Chris is our hands-on manager for data breach and digital forensic investigations. Chris identifies the root cause of forensic breaches, contains intrusions, and recommends security improvements. Additionally, like Esteban and myself, he is a payment card industry forensic investigator with the certifications required to investigate credit card breaches on behalf of the major card brands. Chris also has a master's degree in cybersecurity. The second part of the presentation will focus on legal issues that arise in digital forensic cases and how to avoid common pitfalls. This will be led by Ella Shenhav, a partner at Schutz & Bowen in Tampa, where she is a specialist in privacy and data protection. She litigates complex matters that involve large e-discovery processes and that include hundreds of thousands of pieces of evidence from multiple custodians and devices. She is a certified information privacy professional, and she advises clients on data security and privacy issues. And finally, Luis Salazar will discuss legal issues related to collection and preservation of evidence, in particular, how spoliation of digital evidence can significantly influence the outcome of a case. Luis has 25 years of experience battling in the trenches for companies facing crisis, whether it's a data breach, defending against a government investigation, or undergoing a complex financial restructuring. He also is a certified information privacy professional and advises clients on a broad range of cybersecurity and compliance issues. Next slide. An important housekeeping note, this webinar is eligible for 1.0 general CLE credits, 1.0 technology credits, and 1.0 civil trial certification credits for Florida Bar members. To claim your credits, go to the Florida Bar website and cite course number 230478-1N. Okay, with that, I'll now turn the presentation over to Esteban and Chris. Again, their presentation will last about 15 to 18 minutes, and then we'll move into the legal aspects of this presentation. Esteban, take it away.
Okay, thank you. Next, please. So good afternoon, everybody, and thanks for being here with us today. Today we are going to start this first part of the presentation talking about computer forensics and why it's important. And we're going to provide some sort of tentative methodology and try to answer the most common question that you could have, such as what is a forensic image, or what evidence needs to be collected first, how long investigation takes. That's a very common question that we have all the time, and what can be recovered. And finally, we are going to talk about challenges that we face all the time and some sample of forensic cases. Next, please. So let's start with a definition of computer forensics. So digital forensics is a branch of the forensic science that focuses on the identification, preservation, analysis, and presentation of digital evidence. And it involves the application of systematic and scientific techniques to investigate and recover information from digital devices. One key element here is the word preservation, which is the preservation of evidence, which is the process to safeguard and maintain the integrity of the digital evidence during the investigation and after the investigation. In the case of the PFI investigation that Judy mentioned before, that we do investigation for the credit card information, credit card companies, we need to hold the evidence for at least 3 years. And it involves taking the necessary steps to prevent any alteration, destruction, or loss of data, that ensuring that the evidence remains intact and admissible in court. Next, please. From the data breach perspective, digital forensics help us to answer questions like how did the incident occur, which means that we can how the hacker was able to gain access to the computer. It was due to the phishing attack, and then they was able to get accounts, or was the exploitation of vulnerability because of the lack of the system. When information was compromised and exfiltrated. This is very important for the organization, because that is going to determine what are the next steps, which means, for example, customer notification. There are several laws and regulations. You know more than me. And the customer needs to be notified in a certain period of time. And also is going to help the organization to determine what is the impact, the real impact of the incident. What system or technology were compromised or accessed, who is the perpetrator and how long has been in the system, and the most important thing is if the perpetrator is still in the systems. Next, please. From the litigation and dispute perspective, we can answer questions that, like, did the employee steal intellectual property? Sometimes employees have the tendency when they leave the companies to make copies or to different external hard drives or send things in the cloud. Or then if you have a case that is involved wire transfer, is from where the fraudulent wire transfer was originated, or who did that, or if funds were stolen internally, of confidential data was stolen by somebody inside the organization or a thief. Now, it's crucial to understand that since forensic evidence are only based on facts, these facts can help you to, as mentioned before, unmask a perpetrator. It could reduce the client culpability and also prove an opponent's culpability. Next, please. A methodology is crucial to perform an effective computer forensic investigation. And sadly, there is no one universal accepted process model. And the reason why is any process model are designed to a specific environment, a specific task. For example, law enforcement model might not be applied to an incident response model, with all the information and everything needs to be collected as soon as possible, and you need to deal with an incident right away to contain that the incident doesn't propagate. So the approaches are going to be a little bit different. Nevertheless, the following phases or steps that you are seeing right now are common in each of all the models that they are right now in the market. So the first phase is usually identification, and the purpose is to determine and understand what is the incident under investigation. During this phase, we try to see, okay, what is the objective of the investigation? Who are the people, the key people involved? What are technologies, physical location, and even devices that are involved? Then we have the acquisition phase, where it is where we can define the strategy to acquire digital information or digital evidence. In this case, depending on the technology, the acquisition is going to be different. And the idea here is that we need to take in consideration that whatever we gather has to be securely preserved to avoid tampering. The next step is analysis. Is once we acquire all this information, from that information, we need to extract the actual evidence. We need to determine what is the evidence. Evidence that can support or back up any theory that we have under our investigation. And then we have documentation. All the data that we analyze, we record the data, we organize. What we try to do is to create a picture of the incidents. And finally, obviously, we had a presentation is where we summarize and we explain all the conclusion of the investigation with the specific facts. Now I'm going to give to my colleague Christopher to continue with the next part.
Cool, perfect. Thank you, Esteban, for kind of that brief overview of the digital forensic methodology. Can I go to the next slide, please? So Esteban has kind of given like a background on the digital forensics process and the methodology involved whenever a new case arises. One of the questions that you might have is, well, what are the different types of digital forensic investigations? And realistically, the short answer is anything that has a computer inside of it can be part of a digital forensic investigation. Now we're showing here kind of some high-level ways of categorizing the different types of digital forensic investigations, whether it be a computer forensic investigations, a mobile device investigation, a network investigation, IoT, etc. The list goes on and on. The more that our lives get computerized, to put it in a term, the more areas that there can be for digital forensic investigations. As you might surmise, the largest or the most common digital forensic investigations are those in computer forensics and mobile device forensics, more so computer forensics. Everyone has a laptop or a desktop or a server somewhere, whether it's Windows, Linux, a Macintosh, what be it. All those devices can be part of a digital forensic investigation, and most likely are. One of the different types of digital forensic investigations that is slowly but surely gotten more and more common every year is mobile device cases. I'm sure, as most of you might know, mobile devices are everywhere. Cell phones, you have your Androids, your Apple, sometimes your Microsoft phones, and anything of that sort. Again, if it's computer, it can be part of a digital forensic investigation, and they can be subject to some sort of gathering of evidence, whether it be logs or the full disk or what have you. Next slide, please. Now, with that in mind, having all these sources, what can be acquired? Again, they're all computers. Everything has some sort of digital information. Computers have the RAM, have the hard disk, have SSDs. Sometimes they have their TPM, which is where they store some security code. Mobile devices, the whole device is a source of digital data. But even going past that, your cloud services can be a source of digital data. If you have servers in the cloud, if you're using AWS or Microsoft Azure, all those servers and all that login information is a valuable source of data. So our IoT devices, everyone nowadays is getting some sort of Google Home device, an Amazon Alexa, a new kind of Nest device to control temperature or to control something, to make everyone's life a little easier. All those devices in some way can have the potential of providing digital forensic data. Now, it might be a little bit more or less common, but it's possible. All these things add up to build a story. Next slide, please. Now, when you're trying to build that story from a digital forensics examiner point of view, and you're gathering all this data, you have to store it in a way that is secure, in a way that can represent reality. Many times, especially when it comes to mobile phone forensics and some sort of computer forensics, we have this thing called a digital forensic image. Now, what is a digital forensic image? Well, it's essentially a copy. In some cases, it's a bit by bit copy, and what that means is it's an exact copy of the source of data. This is normally called a physical image because it's normally acquired through a physical means. In other cases, it might be just a copy of a folder or some area in allocated space. And keep that in mind because that's going to be important later. And what that means is that, you know, when you look at a folder on your computer, whether it's your desktop or your downloads or your pictures folder, a logical image makes an exact copy of everything within those folders and nothing else. Now, what are the big differences between a physical image and a logical image? The big difference is that bit by bit copy. A physical image does an acquisition of the allocated and unallocated space, while the logical is only doing an acquisition of that allocated space. Now, these two, terms, allocated and unallocated, might seem a little odd, and you might not know what that means. But just keep it in the back of your head for just a moment, and I'll address it on a future slide. But that will be important. Next slide. Now, we have, when an investigation occurs and we have to decide whether it be a physical image or a logical image or an acquisition in this case, and we decide what we need to, what we need to acquire, whether it's a computer, a phone, an IoT device. The first thing that everyone should keep in mind is, what do I collect first, right? Do I collect the hard drive first? Do I collect stuff from the computer, from the phone, what have you? Well, one of the important rules that a digital forensic examiner is going to have is the order of volatility. And what this means is, when an investigation occurs, we have to acquire whatever is most likely to change first, and then leave those which are less likely to change till the end. Well, what does that mean? More likely to change, less likely to change. Our computer's always running, right? I haven't moved anything, so nothing should change. Yes and no. There are certain parts of different computers that are always changing. This is your caches, your registers, your RAM, which is more common to most folks. That's the random access memory, and that's a part of your computer which your computer uses to do work inside of. And this area, this RAM, has the likelihood of changing constantly. So when an investigation occurs, us as digital forensic examiners, if we feel like it is necessary, we always attempt to capture that RAM first, because if a computer is hit with malware, if someone steals some keys, if someone makes changes, that RAM is going to have a lot of crucial data. And the problem is that data can change very quickly, because that is the nature of that data. While the order of volatility states that if I want to capture something that is less likely to change, let's say a backup, maybe you have a client that is storing files somewhere in a server that they only touch it every couple months. Well, that is less likely to change on a day-to-day basis. So it's okay to push that towards the end of the acquisition or the collection phase, because if it's not getting that many changes, you have no fear of losing data. While with the RAM, it changes so frequently that the fear of losing data is very high. It's always present. Next slide. Perfect. So during the acquisition process, you have your examiner going through, they've collected the data, they have their logical or their physical image, they're analyzing unallocated and allocated space, and they're going through the process, they're trying to recover everything. A very common question that any forensic examiner gets is, what was deleted? I want to see what was deleted on this computer. Now, that question, what was deleted? What was removed? What can I recover? That's the question that drives whether you want to do a physical acquisition or logical acquisition, that unallocated versus allocated fight. Allocated space is the space of your computer that is readily accessible to you. You save some photos on your desktop, you have some documents that you need to read, a PowerPoint, all of that stored in allocated space. All that means is that space is visible to you, the user. Unallocated space is a space that isn't directly accessible by the user, not easily at least. When you have a hard drive that's 100 gigabytes and only 50 are used, and you have 50 of free space, that 50 of free space, that's the unallocated space, and that's the space that can be acquired through physical imaging only, because our tools need to be able to make a bit by bit copy at the lowest level possible. Now, the reason why this is important when it comes time to recover data is that you can only recover data from unallocated space for the most part. And the reason being is, when your computer decides to delete a file, at first it doesn't actually delete it. what happens is that your computer has a ledger, or it has a book, and all the files are stored in the table of contents. At first, the computer, when you delete a file, it only removes the index on the table of contents. It doesn't really remove it from the rest of the document. What happens is, over time, when your computer needs that space, then it'll overwrite it. So that means when someone first deletes a file, there is a possibility of it being recovered, as long as that space wasn't modified by the user, if the operating system didn't need it, etc. There's a lot of factors that go into whether or not something is still in unallocated space. So whenever you suspect that something is deleted and you want to acquire it, trying to acquire it as quickly as possible is your best case to reduce all the factors that can lead to it being overridden or lost for good. And what can be recovered? Essentially anything that's been deleted, as long as it's still there in the unallocated space. Next slide. Now, with all these steps in mind, Esteban talking about the methodology, mind for the acquisition, the analysis, the data recovery, how long does an investigation take? Realistically, there's no good answer. There's a lot of things that there's a lot of factors that go into an investigation that can make it longer or shorter. And these can be the amount of data that has to be processed, the amount of data that has to be acquired, the quality of your forensic evidence, and the quality of the source. If the machine is more corrupted, or the machine has been overridden quite a bit, data can be lost or data can be corrupted. How large your scope is, if it's much quicker to analyze one machine rather than 100. So the more data that has to be processed, and the higher quality that data, the longer it will take. While the less data and the less quality of the data, the less time it will take, and the faster it'll go by. Next slide. And so, what are some challenges overall in the digital forensics space? Well, there's quite a few. As I mentioned, lack of evidence or lack of good evidence. If you have poor IT practices in terms of storing logs, storing backups, ensuring that after an incident occurs, some evidence is captured. If you have a poor IT practice in those cases, that can be a very big hindrance to a forensic case. Anti-forensics methods are also a very big challenge that we have personally seen in a couple of our cases. And this is when a malicious actor does something malicious and they try to cover their tracks. And if they do it well enough, it's very hard to determine exactly what may have gone down on that machine. Other challenges include, the complexity of the data, how quickly things change with every new iteration of an iPhone. It becomes harder and harder to acquire digital forensics data. The newest iPhone is, whenever there's a forensic case regarding the newest iPhone, that's always a challenge, because it's very difficult to acquire evidence from iPhones in a methodical and thorough way. If they're newer, the older the phone, the most likely that we can do an acquisition of that, simply because a lot of companies have to use sort of hacky ways to kind of break in and be able to capture that data. And one of the other issues are encryption. Encryption is a fantastic thing. It keeps all of our data safe, but at the same time, it can keep all of our data safe. It can keep a lot of attackers safe too. So when they implement encryption interactions, as many I'm sure everyone here is common with a ransomware, how prevalent it is nowadays. Those type of investigations are very difficult, because without a key, it's very hard to do much of anything. Next slide. And we just wanted to give you some sample cases that we've kind of done in the past couple of years. We've had two cases with different banks. I can't disclose any specific names, NDAs of course, but a couple of those cases kind of included determining whether an IT executive at the time was running a side business using the resources of the bank that they were working at, and we had to determine for how long it had been happening, and if it was happening. At the end, it was. We also had to determine how an external attacker was able to compromise the CCTVs of the banks to steal very sensitive data that was being input by the members of the call center at the bank. For universities, we've had to help them to determine how their website was compromised and defamed, and when it occurred, and how they could prevent it. And very commonly, as Judy mentioned at the beginning, see, as we are a PFI company, we do help merchants on a regular basis to determine how their e-commerce platforms have been breached, what was the cause, what was the extent of it, how long it's been going on, and what they can do to rectify. So, and, these are just a couple cases in which we can say how digital forensics can help, our clientele.
Great. Thank you, Chris and Esteban. I'm going to turn it over to Ella now. As a reminder, please send your questions through the chat, and we'll wait to those at the end. Ella, take it away.
Thank you. Thank you, Judy, Esteban, Chris. Thank you, everyone at ERM Protect for putting together this webinar. And I'm going to be talking about collection and preservation of digital evidence from a legal perspective. And there's so much to say about that. I only have 15 minutes, so I'll get right to it. Well, first of all, us lawyers, we know how important it is to preserve and collect evidence early on in the process. And, oftentimes when we're just retained on a litigation matter, we will send our client and perhaps opposing counsel or opposing party a preservation letter that sets up the obligations that everyone has under Florida law. Florida courts are very strict about evidence preservation and spoliation. And if you don't preserve it, then you potentially lose it, not just the evidence that supports your party's position, but you might lose a lot more than that. And I put potentially in parentheses, and I'll get back to that because there is a bit of a caveat, and it goes back to what Chris was saying about recovery of deleted information. But when you're thinking about preservation of evidence, a lot of times you have to really think about how to do it from a practical perspective, because you're talking to your client, and nowadays, a lot of these conversations are being had by phone or by Zoom, and you're telling them, okay, you have this duty to preserve anything that could potentially touch on this litigation, even if you don't think that it's tremendously relevant. If it even mentions the other side, you should probably preserve it. Okay, well, if your client is not incredibly technologically sophisticated, how do they do that? If there are multiple record keepers, multiple employees who may have been involved, they could go through all their emails and sift through them with either search terms, or they could ask their employees to pick out the documents that they think might be relevant. But those methods are often just not thorough enough. And then as the litigation progresses and new things come up, all of a sudden you realize, wait, what about this? And you realize that perhaps your client didn't necessarily preserve everything because you didn't think about everything at the very onset of litigation. So, one way of making sure that you're preserving everything is to image the hard drives. And, that's also a great solution for companies that often will reuse a hard drive after an employee leaves and they no longer need that employee's information on particular computers. So they just, format it and give it to a new employee, and then all that information is lost. So if you image it, if you send it over to the digital forensic expert vendor to just image it, keep it to the side, you can use it later, you can upload it, you can run searches through it as the litigation progresses and you realize that you have additional needs. Cell phone data, again, you can image it, you can have someone image it. And what happens with cell phones is that, litigations will last years. And people lose cell phones, they fall into the pool, they get damaged. They'll just change out a phone every couple of years. Now it's pretty standard for people to get a new phone every 2 or 3 years. And then your clients will say to you, oh, well, I don't have that phone anymore that had those text messages or those pictures on there. Or their employees will have, employees who no longer have those phones. And it's really easy to say, well, I legitimately had something that went wrong with my phone, and that's why I don't have that evidence anymore. But can I see the next slide, please? Florida law is very clear that spoliation is not necessarily intentional. So even if you have the best documented reason that, your phone, you were in a horrible car accident and your phone got broken into pieces and it's completely not your fault, it's still your responsibility. And what I see, our slides are flipping a little bit. Spoliation is not necessarily intentional, and if your client is held responsible for spoliating evidence, then the sanctions can be severe. You can get adverse inferences, meaning that the jury or even the judge might draw the conclusion that whatever evidence your client doesn't have would have been negative and would have been evidence that would have weighed negatively on your client's case. And that's, not even the worst of it. You can have your client's pleadings struck. You can have attorney fee awards to the other side, and even dismissal or default judgment in really egregious cases. That doesn't happen very often, but adverse inferences, attorney's fees, striking of pleadings, that definitely happens, something to be aware of. And, oftentimes I will get from clients screenshots of text messages. Sometimes there's apps that are meant to sort of pull a chain of all the text messages. Those are often just simply not enough, because we're looking at a loss of the metadata behind those messages, and also a loss of call logs. And sometimes phones can be used for physical location tracing. So a lot of times, imaging is sometimes the best solution, but not always. And we'll talk a little bit about why not always. Can I see the next slide, please? The advisory committee to Federal Rule Civil Procedure 37E, which deals with the failure to preserve electronically stored information, explained that the proportionality considerations that we use in determining whether discovery is appropriate or not are also appropriate for determining how much you need to do in terms of preservation. So if you have a very small case, then you probably don't need to go all out imaging all of the devices that all of your employees have. If you have a big case, then you might want to do exactly that. But the question is, most cases are somewhere in the middle, and do you want to really risk it and make the determination early on that this case is not that big of a deal, so I'm not going to go through all these steps to preserve information, where later on you're not sure exactly what's going to happen. And also, mind you, this is obviously a federal rule, and state rules have a different criteria under which these things are evaluated. Let's go to the next slide. So we're going to talk just a little bit about privacy concerns, because there's obviously privacy is something that has gained a lot of importance over the last few years. And on this slide, I cited a couple of cases that talk about how a person raising the privacy bar establishes the existence of a legitimate expectation of privacy. The party seeking to obtain the private information has the burden of establishing needs sufficient to outweigh the privacy interests. So a good example of that is when you are seeking to obtain, for example, former employers' personnel records of the litigant against you. And then there's the question of, well, there's going to be a lot of private information in there, a lot of personally identifiable information, PII, potentially protected health information, PHI. Do you need that for the litigation? Is it all relevant to the litigation? The second case that I cited on this slide, also it says that if a case involves personal information, the trial court's discretion to permit discovery must be balanced against the individual's competing privacy interests to prevent an undue invasion of privacy. And I think that what's worth noting is that these cases are from 2014 and 2015, and that's nearly a decade ago. And in that decade, the attention and emphasis that have been given to privacy have increased by at least 5 or 6 times. So however much guarding of privacy rights the courts gave in 2014, 2015, when these cases came about, we can expect a lot more emphasis on privacy rights now. And privacy is a right that is anchored in the Florida Constitution. So certainly something to keep in mind. We don't have time to really delve into all the minutia of privacy and data preservation, spoliation, etc. But as you go about this process, it's certainly something to give some thought to. Let's look at the next slide, please. So we talked yes, that one, thank you. So we talked about cell phones, and the courts have been clear that the right to privacy also protects cell phone data. I talked a little bit about imaging cell phones, and I'm a proponent of imaging cell phones because it just captures all of the information, and you don't have to worry about what it is that you don't have through screenshots. But at the same time, there are some privacy pitfalls here because you are capturing so much more than you actually need for the litigation. And a lot of us, we just live on our phones. I know that I do. I have everything in here. And a lot of it is personal and stuff that I probably wouldn't want to turn over to my lawyer or to my employer's lawyer. And this is an issue that comes up a lot when you're representing a company and you want to try to preserve the evidence on the company's employees' cell phones, and you ask to image them. And if you do image them, you're going to have a lot of these employees' very personal PII and PHI, and you have a lot of sensitive information in your possession. It's true for cell phones, it's true for computer hard drives, but people tend to know not to do anything sensitive on their computer, on their work computers at this point. I mean, I like to think so at least, but on their phones, you're going to find their entire life. So imaging definitely brings up some privacy concerns. Con, let's jump to the next slide. So that brings us to attorneys' responsibility to safeguard privacy, because when you are, as an attorney, you come into possession of either your client's information, your client's employees' information, or the other side's information. You have a duty to preserve it, and you have a duty to set up certain technological and also employee-based safeguards. And employee-based because the majority of cyber attacks are the result of human error, like opening a phishing email. And you have this obligation, not just as the attorney, you yourself, but also your staff. Is your assistant, is your paralegal, is your office services people, are they all trained and aware of exactly how to safeguard all this information? And that's something that, oftentimes we do these cybersecurity trainings when we hire someone. And then, maybe once a year, we'll do like a little 30-minute refresher nobody really pays too much attention to. But this is crucial because you are holding a treasure trove of personal information that oftentimes is actually not really that relevant to the litigation. You're just holding it just in case. And as lawyers, we also tend to not delete this information after we're done with the litigation. So we may box up our banker boxes and put them away in storage, and we may, send a nice closing email to our client. Thank you so much for letting us represent you. But we don't go back and say, okay, we have a lot of PII and PHI on our systems now. We no longer need it. Let's purge it. It's just usually not something that's part of our regular process, and it's something that we should definitely give some thought to. With respect to, I mentioned imaging your client's employees' cell phones. Another concern or another consideration that we should all be thinking about is what happens if later on in the litigation, your client and that employee whose phone was imaged as part of your client's defense or claims, what if they become adverse? So for example, if there's discrimination lawsuit against your client, the corporation, based on the actions of its, let's say, CFO, and your client is defending it, as part of that, we take the CFO's laptop and cell phone and image it, and later down the line, we determine that the CFO actually did discriminate, and now the company and the employee become adverse to each other, and your client may want to bring claims against that employee, now perhaps a former employee, but now you have all this highly sensitive personal information in your possession because of the imaging. So it's very important to think about how you store it, how you access it, how you make sure that you're not actually viewing more than what you should be viewing. And you might want to talk to a forensic expert or vendor to help you kind of sift through that without you actually going into that employee's very personal and not at all relevant information. Colin, let's go to the next one. And as part of our responsibility as attorneys to safeguard the privacy, we're charged with challenging discovery requests that demand more private information that the case calls for. We talked about proportionality, and we talked about how these privacy concerns are becoming more and more weighty. And as we're getting these interrogatories or requests for production that ask for everything and all, we need to be thinking, okay, can we object to this on the grounds of privacy? How is it relevant to the litigation, and how can we best serve our clients to not turn over more than what is necessary? So, Colin, next slide, please. So I mentioned earlier that preserve it or potentially lose it, and Chris talked about recovering deleted information. And I will say, like Chris said, these deleted files, they hang around the memory even after deleted, after the trash bin is empty. And there are some privacy laws that actually require you to go in and do a very thorough deletion process. For example, if a company operates in the EU or in California, consumers there have a right to be forgotten, meaning that they have a right to request that their information be deleted. And it's not enough to just delete it on the surface like Chris described. You have to really go in and purge all that information. And in the litigation process, a forensic examiner can really help you retrieve the files that someone thought that they had deleted. And it's a double-edged sword, because obviously, if your client says to you, oh, well, I deleted those files, then you can go to a forensic vendor like ERM Protect and have them recover that. But what I had happen to me, and I only have a few minutes late, so I'm gonna go through this really quickly, but very recently, just about a month ago, I went to trial on a matter that was very truncated. We took over from former counsel. Discovery closed about 3 weeks before trial. And as part of discovery, we took the deposition of the president of the plaintiff, and he admitted multiple times during his deposition that he deleted all of his text messages and emails, just routinely, delete. He said he did it to preserve the environment because of the server power that requires to hold all that information. So of course we filed the spoliation motion, and the day before the spoliation motion was to be heard, we got a letter from opposing counsel saying, oh, we're so sorry, our client is not technologically advanced. He thought that they were deleted, but we used a digital forensic expert, and he was able to recover all these text messages and just gave me a document dump of thousands of pages of text messages, most of them completely unrelated. Just they drowned me. This was about a week and a half before trial. They figured they're done with it, no need to worry. Well, yeah, I'm a little bit, crazy about these little things. So I actually sat there for hours and hours and hours, all through that day and night, and reviewed all the text messages. It was clear that they hadn't done that, because when we got to the trial, I confronted the president with several of his newly produced documents, which it was clear that he didn't remember sending them, because they were years old and he clearly hadn't gone over them, and it really made him look very, very badly, because he was contradicting himself. But the point here is that had they done that from the get-go at the beginning of the process, there wouldn't have been a spoliation motion, there wouldn't have been a last-minute production of documents, there wouldn't have been this surprise to them at trial using documents that they didn't even have time to go through. Whereas if they hadn't done it at all, period, then we possibly could have gotten spoliation sanctions. So, they should have done it regardless, right off the bat. If your client tells you, I just deleted my messages, that doesn't mean they're gone, you can still get them. And last slide, Con, really quickly before I turn this over to Louis. You know, I had a couple years ago a case that had, we were suing these two fairly high-ranking employees who were both in the IT department, high up in the IT department, and they were both charged essentially with accessing and stealing documents that they shouldn't have had any access to. And they both just flat out denied it. They gave us the whole, my phone fell into the pool and my iPad fell into the toilet, et cetera, et cetera. Long story short, because I won't turn this over, but we did hire a forensic vendor, and they were able to provide a 100+ page report of exactly everything that these employees accessed, touched, the purging tools that they downloaded to try to clean up after themselves. It was a highly detailed report. And very shortly after we got this report, we managed to settle in a way that my client was very happy with. So definitely something to think about. You know, these vendors can be extraordinarily helpful in these litigation situations. And I will turn this over now.
Great. Thank you, Ella. Sorry about the glitchy slides. It's not Colin's fault. I have a feeling our graphic artist inserted automatic forwards in these, so he's having to go back every now and then. So, Louis, you're up.
Judy, thank you very much. Thank you, and thank ERM for including me in this panel. This is a really important topic, one that's constantly evolving, one that we learn something new about almost every day. And I've learned a lot just from my fellow panelists, from preparing and from hearing them today. So my spin on this is going to be how to the overview of how to present a case that is driven in part by spoliation, by discovering it and then presenting it to the court. This kind of digital evidence, this kind of spoliation, as Ella already indicated, can be a big mover in cases. And the kind of work that we do, we focus on high value, high stakes cases. Tens of millions of dollars can ride on evidence being properly presented, evidence being available, and finding out that evidence, in fact, was somehow manipulated or deleted. So let me ask Colin, if you move forward to the next slide. Maybe the first thing we want to talk about is digital evidence as evidence. We've all become used to, as our prior panelists have indicated, and as we all know, we've become used to this electronic environment where messages come in on email, and we tie them mentally to a text message and maybe a post, and it's a digital file attached. We're able to authenticate it, put them in the proper context, and understand those messages very easily. In fact, we all kind of have a mental authenticator at this point. If you receive an email, you might mentally run through a checklist. Is this from someone I know? Does this legitimately look like someone I know? Why would they be sending me an attachment? Well, so the law essentially has several filters to get that same process, to verify evidence into proof for a trial court or trier of fact to consider. Trial courts look at things like relevance. Is a piece of evidence going to more likely than not prove a consequential fact or demonstrate that it's more likely than not true? So first, things have to be relevant. A lot of digital evidence might be interesting. It might be damning in some respects. It might have things that are personal or embarrassing, but they won't be admitted. Then there's the issue of authenticity. How do we prove that what we're showing to the court is actually what we say it is? Whether it's an email or a text, lawyers need to establish that there is some kind of personal authenticator. Someone comes in and said, that is my email, I sent it. That's an email, I received it. That data file, I created it. So you have to have some kind of basis to get it in front of the court, admissibly in front of the court. You have to also, chain of custody applies in that instance as well. So for example, if our friends at ERM will come in and collect data from a computer, a laptop, a device, they have to be able to demonstrate adequately collecting that information, transporting it, moving it, analyzing it, and presenting it in court without actually damaging it or altering it in any way. So we want to be able to preserve that chain of custody. And even if we do all that, courts still have to look at some other evidence type issues. For example, hearsay, which many people, those of you who may not be lawyers out there may have heard, but basically it's an out-of-court statement being made to prove the truth of the matter asserted. So if we're trying to present emails or text messages or WhatsApp messages in court, those are all out-of-court statements. So they have to fall into several potential exceptions. It might be an admission, someone admits they did something poorly or did something incorrectly or breached a contract, Or it might be a business records exception where because of the way it's regularly maintained, it's admissible around hearsay. Colin, next slide, please. So let's say now, let's talk a little bit about, as a lawyer, I'm trying to present my case. I'm trying to get that kind of evidence that I can present as proof at a trial. We've already talked a little bit about the preservation requirement. Is there a reasonable likelihood that you'll be involved in litigation? So that border is very difficult to define. And many times you'll start a lawsuit, or there'll be litigation that the recipient, the defendant, really never knew was coming. It might be a product liability issue. It might be a breach of contract. So they may never have taken any steps to preserve evidence. And that's why litigation holds are so important. But even the litigation hold is a moment of a tactical moment in a longer term strategy. Before sending a litigation hold, the lawyer has to determine, along with their client, is now the right moment to do that. Certainly, it may stop the deletion or modification or altering of evidence, digital evidence especially, but it also alerts the other side that there's a lawsuit. That may prevent an internal investigation from remaining accessible through discovery. It might convert it into a protected work product investigation. It might also present a situation where they are now aware of the lawsuit. They might race to the courthouse before you do. So there's venue selection issues. But assuming that you make that decision to send the litigation hold notice, that's your opportunity to set the groundwork, to set the framework for the digital evidence you want them to protect. So that notice is not a formula. It's something you have to think about. The notice is going to contain, as broadly as possible, a description of what the dispute is, as broadly as possible, the custodians, the number, the kind. You're going to identify the kind of digital evidence you want protected. You're going to identify the steps that you insist that they take. And those will all be general best practices, because at some point you'll be asking witnesses, comparing their behavior to that notice and see if they diverged from that notice and didn't take the appropriate steps. Now, next slide, please. There we go. So let's talk about legal tools for uncovering spoliation. We're talking about really a lot of high-tech devices, a lot of high-tech issues here, but lawyers' tools, as Elle has already indicated, lawyers' tools for recovering digital evidence and determining spoliation are as basic as they have been for 100 years. It's requesting documents, it's interrogatories, questions that have to be answered under oath, written questions, admissions, things that you specifically ask another side to admit to as true or false. Then there's depositions, sworn testimony under oath, witness statements, and depositions of third parties using subpoenas to get outsiders to litigation to also present documents and testimony. We build on all that to determine exactly what the universe of digital evidence is to obtain all that digital evidence. And it's a mix of broad topics and narrow topics designed to drive the discovery and production of the documents that will be supportive of our case. It's important in that process to have someone like ERM on speed dial, because as lawyers, we may be great in certain things, but not all of us. In fact, most of us are not experts on issues of digital forensics. So you want to have a consulting expert. You can pick up the phone and ask, I've got this data. Does this sound legitimate? They're saying they can't access this other kind of data. Is that possible? You may need them to come and look at the metadata, see if it's been manipulated. So that's the double step where you employ to screen out the digital evidence and understand whether or not spoliation has taken place. Could you move on to the next slide, Tom? Thank you. So what kind of common evidence and signs and patterns of spoliation are there? Common signs again, from a lawyer's perspective, non-technical, you're looking at gaps in custodians, gaps in dates, gaps in responses, gaps in types of devices that were not turned over, because all of those could be indicators that something is hiding, right? There's someone is withholding some kind of information. You're going to look also at internally. I mentioned the litigation hold. You're going to compare that and say, is someone else, do they have internal policies to protect documents? What steps, when you depose someone, you're asking them a question, what steps did you take to protect the data? What steps did you take to recover that data? So you use that kind of information in order to determine whether or not there are gaps. But then again, you employ someone like ERM to come in and do a deeper analysis if necessary of the data files to see if there's been manipulation, to see if things have been deleted. if you're able to get access to devices to determine whether or not the devices show evidence of deletion or manipulation. There's a lot of challenges. Prior panelists discussed cell phones as a constant problem. It's hard to determine if someone says, I don't send text. It's hard to prove that untrue unless you have access to the recipient's texts. So there are some things that are very challenging in terms of spoliation and continue to be to prove. Next slide, please. So how do we build a case for spoliation, right? So we've sent out the discovery. We've managed to get back all those documents. We, of course, spend a lot of time becoming very familiar with the documents, understanding where there might be gaps. We want to be able to present that to the court, but look, electronic discovery and electronic discovery disputes are as exciting as looking at an inbox, right? They're not very engaging. So we have to make it engaging to that trier of fact, engaging to the court. So we want to create a timeline. Let's make sure we set the information on what happened in some chronological order. We want to present the discovery that we found, that what we requested, what was produced, what appears to be missing. We want to use a digital expert, either as a consulting expert to coach you on what to say, or to present a written report explaining how the data has been manipulated, the data has been missing, or it's deleted. And let me tell you, if you have a written report from someone like Judy Miller, a Pulitzer Prize winning former journalist, 2 decades as an investigator, you get that written report, and that's a critical factor in convincing a trial court that something has happened here. On top of that, you have to appeal to a court's psychology, the desire to correct a problem. So you need to explain to them, like, how is that negatively affecting you? Why does it matter? And you have to show them whether the other side has engaged, did they actually implement a litigation hold? So you're layering all these things on and give the court a reason to say there's something to look at here. I need to take some action. Colin, could you move to the next slide? We talked a little bit about potential legal remedies already, but let's just say if we're already moving and there's an issue of spoliation in terms of litigation, often that's the advantage you need to resolve a matter, to obtain further discovery. So the fact that it's an issue alone is in some sense a win, but there's a broad range of other remedies that are possible. You can obtain permission for further discovery, to take depositions of individuals that otherwise might not be immediately accessible in normal discovery, in the basics of discovery. But then you can also get legal fees, right? Monetary damages for what you had to go through to prove or to obtain documents that have been spoliated. And we've used that word spoliated, but to be clear, that could, and perhaps the most damaging kind is deletion, but there's also altering, suppression, just simply hiding it, not presenting it, not making it readily available, even though they have it. That also can be spoliation. So there could be sanctions for that as well. In leveling up a little bit more, there could be an inference that the court, the trier of fact, will apply. An inference that had this document been produced, had this electronic evidence been available, then if it had been available, it would have been prejudicial to the other side. It would have made their case, their likelihood of winning less so. And you should in turn have an inference, a beneficial inference from the fact that the evidence was spoliated. And in the worst cases, the intentional cases where someone's actively deleting files, the court can directly enter in judgment in your favor. So it's a very powerful series of potential remedies. What do you want to do? What's the strategy for getting that? The key thing is to show, look, our system doesn't work if people are perjuring themselves, if they're not producing documents, they're hiding documents. Our system can work to resolve disputes, but only if really everyone's playing 10 fingers on the table. So what you want to show to the court is that you need to level the playing field. Something has happened that made the system not work, and it's hurting your client, and it's hobbling your client's efforts to present a case. And more broadly, you want to show them that there's an integrity of the system issue. If there's someone hiding or destroying evidence, that's something that harms everyone. So the court should take action to punish that particular person, but also to show everyone that this is a serious issue that has to be taken seriously, and there will be consequences for that kind of intentional action. Colin, if you don't mind moving forward. Next slide, Colin, please. I'll start. Oh, this, you already did that. Thank you so much. A couple instances where I've used the services, as a matter of fact, of ERM as a digital forensics expert. I echo what Ella said. If you have a client that is going into litigation, or you think is going to litigation, and they have a good case, they have strong evidence, you want to eliminate the spoliation issue completely, mirror the devices, especially the bring your own devices to work, the personal devices, the mobile devices, the ones that can fall into the pool. Get those mirrored now. You'll have that. And I've asked and I've used our folks at ERM to do exactly that. Conversely, I've used them to mirror devices on the other side. I've used them to threaten that I'm going to mirror devices on the other side. And that is a big motivator in actually getting a breakthrough in discovery to produce actual documents that are being withheld. It's a motivator often to resolve cases as well because of the concern about what might be found on those devices. I've also used them in an instance where we had a data breach, lost tapes, backup tapes. And I used to find folks at ERM to analyze those tapes and determine that the manner of it being stored, the type of storage device, and the software were so unique that it was effectively encrypted. We were able to convince the Attorney General that a notice, the data breach notice, was unnecessary. And I've also used them effectively in the context of an insider fraud, when someone is actually stealing from the company as on or before they get terminated. ERM goes in, digitally mirrors, makes a forensic copy of the computers that that person used, but then also goes in there and recovers files, recovers emails, and gets the hard evidence we need to confront the person committing the fraud, to follow up with them and find out where they're keeping additional evidence, what they might have done with stolen funds and the like. It's an incredible edge to be able to go fully informed before dealing with those type of issues. But Judy, that's all I have. Colin, thank you for your help.
Great, thank you. I see we're up against the time clock here. We'll answer your questions via email. And meanwhile, just a couple housekeeping slides that are important. I'm going to leave this one up here for a minute. Again, please cite course number 2304781N to get your Florida bar credits. And Colin, if you could go forward. Also, I want to thank ERM Protect and my boss here, Silker Gonzalez, who provided the resources for this webinar. As you can see, our firm does pen testing, IT compliance assessments, digital forensics. We do cryptocurrency investigations with the advent of ransomware, security awareness training, PCI QSA, audits, and comprehensive security assessments. Next slide. Schutz, I'm sure if you're here in Florida, you've heard of them. They're a full service law firm that provides high quality legal services to businesses and individuals for more than a century. I believe they were founded right here in Miami, and now they've got 300 attorneys and 8 offices around the state. Thank you very much, Ella and her firm, for your support, participation. And Salazar Law serves businesses and individuals seeking to seize financial or business opportunities through startups, mergers, acquisitions, and divestitures, or confronting financial crisis and complex commercial litigation or government investigations. Thank you, Louis, for your participation.
Thank
and
you.
Again, I will make sure that any of these questions get answered via email. And thank you all for attending today.
Thank you, Judy.